Hi everyone, this is Justinian Lane with Justinian Associates, and I'm here today with my lead attorney, Erik Walker. I've got a couple of issues to talk about today. It's been a busy couple of months for us. And one of the things I want to talk about today is you all see in the news, so-and-so got a gigantic jury verdict against some major corporation. Wow, that's got to be great, right? Get say maybe a $55 million verdict. But the story doesn't end there with just a big verdict. There's almost always an appeal that's involved. And Erik Walker was part of an appeal team, an appellate team is what it's called, for a $55 million verdict against Honda in a case called the Martinez case. And I'll let Erik talk about what happened in that case and what his role was in the appellate team and how things worked out.
I worked with a lawyer named Howard Bashman from Pennsylvania, who is arguably the top plaintiff's appellate lawyer in the state of Pennsylvania. It was a Pennsylvania case, so they had Pennsylvania counsel. I had worked with the plaintiff's lawyers years ago in another litigation, and they asked me if I would come on board and work with Howard on the appellate briefing and the oral argument to the Court of Appeals. The case was a very sad case. It involved a gentleman who was driving a Honda vehicle. He had a blowout of his tire, and his car flipped over. And as it landed on the roof, his head smashed against the roof because the seat belt that they were using, which was an inferior type of seat belt, did not prevent his head from moving 6 inches away from the belt and toward the roof. And so he smashed his head on the ground as the car rolled over, and as a result was literally paralyzed from the neck down. He is a quadriplegic. He can't move any part of his body. Literally has to be turned over every few hours at night in his bed to avoid bed sores, can't do anything on his own, and will need constant around-the-clock nursing care for the rest of his life. So the jury verdict of $55 million reflects the fact that he's lost every bit of income earning potential he had, and he has quite a few years left of life expectancy, and he will have to hire nurses for the rest of his life for 24-hour care. There's only so much his family can do. They can't provide the specialized nursing care that he will need. So it's a very sad case, but obviously the verdict was a very important one for the family. After the trial had occurred, and while the appellate deadlines were looming, the Pennsylvania Supreme Court changed the law of product liability midstream. And so the issue on appeal was whether or not the new law, as interpreted by the Pennsylvania Supreme Court, was such that the way the case was tried was not consistent with that law. And the appellate court in Pennsylvania ultimately decided in our favor and said that the case was tried in conformity with the law, even as changed by the Pennsylvania Supreme Court, and they affirmed the judgment of the trial court based on the $55 million jury verdict. And while the case then was mediated after the appeal and settled for a confidential amount, presumably the family will be able to make sure that their former breadwinner's needs are taken care of for the rest of his life.
Now, Erik was asked to be part of this team because he has a very stellar reputation in the plaintiff's community for just being an excellent advocate at appellate courts. And while the case did resolve in a mediation for presumably a very good amount of money, would I be correct in assuming had you lost the appeal, it would not have resolved favorably for the clients?
No, I think it would have gone, the defendants would have appealed to the Pennsylvania Supreme Court. Once you get to that level of appeal, where it's the state's highest court who's considering the case, or in the federal system, the United States Supreme Court, typically those courts can decide whether or not they want to hear the appeal, and they hear appeals only in a limited number of cases. Typically it's where there is a brand new question of law that needs to be resolved, or whether there's a conflict in the lower courts of law. I don't know that this case would have been one the Pennsylvania Supreme Court would have taken. They had already taken several cases on the same issue. In all likelihood, they would have probably refused the case, and the appellate verdict would have stood as it was. But you don't want to take that risk if you don't have to. If you can resolve a case in mediation on terms favorable to your client, it's best to do that. There's an old saying that the best mediation is one where everyone leaves unhappy. And that means the defendant gave up more than it wanted to give up, the plaintiff took less than they wanted to take, but in the end, everyone left with a satisfactory result. And that's, I think, what happened in this case as well.
Right, and as Erik was saying, it's never a given that a Supreme Court is going to take a case, and it will add a significant amount of time and complexity just to try to persuade them to do so. So, I mean, even if the court had heard, that would have added, what, a year before the family? At least a year. So that's the thing that we often explain to our clients is, you know what, we want at this level, the defendant's going to appeal, we could settle it for less, and why would we do that? So you could get paid now versus the uncertainty of adding maybe a whole another year or 2 years or longer. One of the bad things, unfortunately, about our justice system is the wheels turn very slowly, and there's not much that we as lawyers can do to speed things up to make that happen. So we're always amenable to a mediation or an arbitration if we can do that to try to, if that's what's going to be in the client's best interest. Some of our clients are fortunate enough that they don't need money immediately, so they're willing to take the long, drawn-out process, and versus others, they just want to settle and get money as quickly as possible, even if it's not an amount that we would recommend them taking. We'll follow their orders there and give them our recommendation on what they should do. Now, the case you were working on, this was all under Pennsylvania law, is that right? Were there any particularly novel issues in there that you had to research that was kind of new to you or very complicated, or?
Well, not anything particularly new. It was, basically it involved the Pennsylvania Supreme Court sort of choosing what parts of law that other states had applied that they were going to apply to Pennsylvania. And because it was a new Pennsylvania Supreme Court decision, even though it was a very lengthy decision, there were a lot of things that have not yet been resolved, even in that opinion, and it will take years of lower courts hearing these issues and considering them before the matters get resolved, because all the Pennsylvania court did was look at the case in front of it, say, here's what the law is going to be that will apply to this case. But of course, future cases like ours would involve circumstances that were a bit different, and how that law will apply to different circumstances is still an unknown, given the recency of the Pennsylvania Supreme Court decision. And that takes time to flesh out. And that's what we were trying to do with the appeal, was to show how that law applied to our particular set of facts and show the appellate court that the way the case was tried and the decisions that the trial judge made were consistent with what the Supreme Court had decided.
And that's something that's kind of frustrating also about the way the law works that I didn't really understand until I went into law school is when a Supreme Court makes a decision, they oftentimes don't give a lot of guidance. They'll just say, well, this is the rule, but they don't tell you how to apply it or think about the second or third order consequences. And that's up to the lower courts. And that can take years and years and years before everything's resolved and people know how things are supposed to work. I think that the United States Supreme Court has probably thrown some things into disarray that's going to take years to shake out with some new decisions that came out involving something called personal jurisdiction. Now, personal jurisdiction is just kind of a fancy way of saying, where can I sue somebody? If you're an individual and you reside in Texas, you can get sued in the state of Texas. You probably didn't need me to tell you that. If you've never been to California, you probably aren't going to be able to get sued in California. You probably figured that too. But it gets different if you're a big corporation that has offices in all around the country, that does business everywhere. And because some things have recently happened that have thrown that into flux. And Erik, do you want to kind of talk a little more about that?
Yeah, there have actually been two Supreme Court decisions from the United States Supreme Court that have come out in the last no more than 3 weeks that have thrown things into flux. And it really began in 2011. Let me preface all this by saying that personal jurisdiction is really a question of fairness. If you have, for instance, an individual who's never been, as Justinian has said, has never been to California, and they get sued in California for something they did in Massachusetts, that's not fair. It's not fair to make that person travel to California for hearings and depositions and a trial if they've never been to California. So we have this doctrine called personal jurisdiction. It's basically a due process consideration that says you cannot sue somebody in a place that's alien to them. So in order to establish that a court in a particular state has personal jurisdiction, you must either establish that the state has general jurisdiction over the defendant or specific jurisdiction over the defendant. Specific jurisdiction exists when the tort involved, when the cause of action, what you're suing for, is based on events that happen in the state. So for instance, if I have never been to California, but I take a trip out there and start selling a bunch of defective widgets in California, and then I come back to Texas, and somebody is injured by one of those widgets I sold in California, they can sue me in California because their injury came directly from an event that happened in California, my sale of widgets to them. But if I have my little widget company in Texas and I sell only in Texas, and somebody buys a widget from me in Texas and takes it to California and somebody gets injured with it, I can't be hailed into court in California because of that event. There's also general jurisdiction, which says that if an individual or a company or a corporation has certain minimum contacts with the state that are so substantial and continuous and systematic that it's fair to bring them into court in that state, then there will be personal jurisdiction. And for many decades, really since the original Supreme Court decision in a case called International Shoe came out over a century ago, I believe. I think it was actually the 1800s. But in any event, as long as International Shoe was the law, it was pretty much understood that national corporations, certainly multinational corporations, are subject to jurisdiction in really just about every state where they do business, where they have sales representatives, sales offices, manufacturing events going on, advertising, etc. Beginning in 2011, the United States Supreme Court has issued now 4 different decisions that have cast doubt on that, and we're fighting that now, or dealing with that now at the appellate level. One was a case in 2011 called the Goodyear case, in which the court said that general jurisdiction, which we used to consider to be any state where the corporation does a lot of business, the court said that general jurisdiction is limited to the corporation's home state, where its headquarters is, or a state where its contacts are so significant that it can be deemed a second home of the corporation. But a corporation generally will only have one home, and that's the only state where there's general jurisdiction, which would mean that you can only sue the corporation in the state where it was incorporated, the state where it has its principal place of business, or the state where the conduct leading to the injury actually occurred. The court reaffirmed that principle in a case called Daimler in 2012, and then just a few weeks ago in a case called BNSF versus Terrell that was a case they heard from Montana. They once again reaffirmed this principle. The California Supreme Court heard a case involving Bristol-Myers Squibb where they said that, okay, if that's the law, that's okay, but if there have been so many contacts with the state that really the corporation has a substantial amount of activity going on here, we're going to deem specific jurisdiction to exist. And in a case issued just this week, on Monday of this week, the High Court, the United States Supreme Court said no specific jurisdiction from extensive activities. You have to show that the injury actually came from the activities that occurred in the state in order for personal jurisdiction to exist there. So the whole jurisdictional issue is now very questionable in states where the corporation is not incorporated, doesn't have its principal place of business, or where the activity leading to the claim didn't occur. There's still an issue of consent. If a corporation complies with registration requirements of a state, if the state requires a corporation to register to do business in the state and to appoint what we call an agent for service of process, meaning they're required by law to appoint somebody to accept summons and accept complaints against them, that they have essentially consented to jurisdiction in that state, even if personal jurisdiction would not exist otherwise. That's an issue where the lower courts have overwhelmingly found in favor of the plaintiffs, saying that regardless of whether there's personal jurisdiction, if the corporation registers to do business in the state and appoints an agent for service of process, they have consented to jurisdiction. And that makes sense if you think about it. If you're going to avail yourselves of the benefits of the state law and of the state procedures to do business in the state, And the state allows you to do that and requires you to appoint an agent for service of process and deems that appointment to be a consent to it being hailed into its courts, then you can't complain about personal jurisdiction. You can't have your cake and eat it too, so to speak. It's an open question as to what the Supreme Court will do with that issue, because while they were confronted with it in the recent case from Montana just a couple weeks ago, they did what we called punted on the issue. They decided not to decide it. The Montana Supreme Court case that they were reviewing had not addressed the issue, and so they said they'll wait to another day to address the issue of consent. So the plaintiffs still have a strong argument for why litigation that's currently pending before state courts that aren't the corporation's home state courts have viable claims pending. But it's an open question as to what the Supreme Court will do with that. We'll wait and see.
And this is all very important for injured people, especially who took like a defective drug that causes injuries, because you have a choice. Well, maybe we do, depending on what the Supreme Court has to say on where you can file your lawsuits. And some states are friendlier to injured people than other states. So a lot of folks try to file lawsuits in the state of California because their courts and their legislatures have chosen a path that makes it maybe a little easier for people who are injured to get compensation than a state such as Texas, which is a little less friendly to injured people. So what's really interesting and is up in the air is what happens to all of the cases where they've already gone through and been filed in a state court, and now the new court decision that came out says they never should have been here. And that just actually happened with some cases in the pharmaceutical arena, if I understand correctly, and that now some recent judgments and stuff might be at risk. Is that right, Erik?
That's the open question. First, we have to wait and see what the Supreme Court does on this consent issue. It's still an open question as to whether the cases filed in state court consolidated proceedings, these are state court proceedings where there is a litigation pending that involves hundreds or thousands of cases from around the country before that one state court judge. It's an open question still as to what will happen with those cases, because there's still this consent issue out there that the Supreme Court has not decided. But assuming things went bad for the plaintiff's bar in that respect, and the Supreme Court were to find that there is no consent and there was no personal jurisdiction in those states, the question becomes what happens to all the cases that are pending there, particularly the cases that have already gone to trial and earned, verdicts for the plaintiff, in some instances multi-million-dollar verdicts that are up on appeal. I think that if everything went against the plaintiff's bar in those cases, those verdicts, of course, would be set aside, and the cases would have to be retried. What's an open question as to whether plaintiffs could then refile the cases in a court that does have jurisdiction without there being an issue raised that the deadline for filing suit has passed, the statute of limitations has expired. Generally, we have a doctrine called the tolling doctrine. It's an equitable doctrine that says that in certain instances, the statute of limitations will be tolled during the time a lawsuit was on file. This happens in cases where someone files in a court with proper jurisdiction, but the court ultimately decides that it would be inconvenient to the parties for the case to proceed in that forum. That's a doctrine called forum non-convenes, in which either party can raise the forum non-convenes issue and say it's not convenient for litigation to occur here. And in those instances, the state court will dismiss the lawsuit conditioned on the defendants not raising the issue of the statute of limitations. And the defendants agree to that in order for the case to be dismissed. What I don't know has been resolved. I've not researched the issue yet, so I can't say it hasn't been resolved by some courts, but I have not seen the decisions on this issue yet, is whether if a case is dismissed on jurisdictional grounds, meaning the court had no discretion to put conditions on the dismissal, it just has to dismiss the action, whether the subsequent court where the case was filed would find that the statute of limitations was tolled while that case was pending before the court without jurisdiction, such that the case can be brought in the new court. That's something I don't know the answer to yet. I'm going to be researching it. I actually have a presentation to give in a plaintiff's conference that's coming up in July. I'll have the answer then, and I'm sure we'll address it on subsequent broadcasts here.
Absolutely. Erik has been asked to speak on this topic. It's not the first time he's spoken on it, but it is. He said these cases just came out, one of them earlier this week. So we're researching and figuring out what the law is, or should be, or could be.
And let me dovetail in that, if I could, Justinian, real quickly. I have been warning people about this. I saw this coming when the Goodyear decision came out in 2011. It was clear to me that this was going to be a difficult issue for the plaintiffs. And so I've given speeches in, I believe it was Toronto. I gave one in Santa Barbara that Justinian was at before I had joined this firm, admonishing lawyers to be careful about relying on these state court consolidated procedures. We don't rely on them here. When there is a federal multi-district litigation set up, a federal MDL proceeding set up, we file our cases in the MDL because there's no question there that we're doing everything according to the rules and that our clients' interests are protected. We have not taken advantage of some of the state court consolidated proceedings in large part because we know this risk that existed. And so that's another advantage, I think, of this firm. But of course, you know, we talk about these advantages all the time. We look out for interests like that, and we're very concerned about things like that. And we have filed in proceedings where we know our clients' claims are well protected.
Right. In some of the drug cases that we handle, we've had a choice. We could either file it in the federal courts or we could file it in the state courts. And some attorneys think you're better off in the state courts. It's a little more advantageous for an injured person. Others prefer to stay in the federal courts, and we prefer to stay in the federal courts if we can. And as Erik was discussing, I mean, kind of the nightmare scenario for some of these people in their state court proceeding would be that they've filed their case. It's been sitting there for a long time. The new Supreme Court decision comes out that says this wasn't a proper place to file it. They get dismissed, but then the statute of limitations has run out because they don't consider it to be told, and now those people have no remedy at all, and they just lose. Whereas we made the gamble, we'll put it in the federal court, and we're fine. We'll be safe. We can't obviously know if we're going to get a recovery, but we do know we won't be thrown out on these grounds.
Right, even if the state where the federal court sits, we're deemed a state that didn't have jurisdiction. In the federal system, the federal courts can transfer the lawsuit to another court in the federal system. So if we filed a lawsuit in Texas and it was deemed that Texas didn't have jurisdiction, but Arkansas did, the federal district court in Texas could transfer the lawsuit to the Arkansas district court. So there'd be no dismissal, there'd be no statute of limitations issue. And when you file directly into an MDL or multi-district litigation court, they will always send the case back to a court with proper jurisdiction when the MDL proceedings are completed. So we really run no risk when we file in MDL procedures or in federal court. There are some risks to filing in the state court procedures, and we've chosen to avoid those risks wherever possible, certainly when there's an MDL that exists in the federal system.
And if you get the impression that all this stuff is extraordinarily complicated, you're not wrong. This is not easy. Some of the largest law firms in the country they're debating how should we proceed, what should we do. Opinions can and do differ, but I think everybody would agree that if you do have a complicated case involving a drug injury or a serious car accident where the manufacturer might be at fault, you should hire attorneys who understand the issues so they can at least make an intelligent decision. Some attorneys, on the different side of the issue, they might have gotten it wrong, but that's totally different than, wow, I didn't even know that was an issue and I just guessed. So we try to take a really long view and think of what's going to be best and what are the risks on the horizon. And as Erik said, he's been blowing the horn on this since 2011, trying to warn people this is the direction things could go. So, we think we made the right gamble for our clients in making sure that they won't have this particular issue. And it's just one of many that come up. There's always tension between state laws and federal laws and which court's going to do which thing, and you kind of have to, they say, read the tea leaves and figure out which way to go. So we always err on the side of protecting our clients. Not all firms will do that. If you've got questions about jurisdictional issues, you can certainly contact us. For those of you who might be in law school watching this, boy, it's going to be interesting for you guys because your civil procedure books are going to have to be rewritten. The Supreme Court keeps changing pretty fundamental laws term after term. And it's very interesting. I know just the things that I learned. I graduated in 2010. International shoe was the law of the land for a lot of that. So things are changing, and it'll be interesting to see where things go. That's an advantage of going with us as a firm is, Erik has a lot of appellate experience and a lot of trial experience. I think we actually have a couple of interesting trials coming up later this year. We'll keep you posted on how those are going to go. Those will be right here in Austin, and we're anticipating, I know you've been part of some trial teams in Philadelphia for some of the mesh cases, and we're anticipating some additional trial work then, but probably don't have enough to talk about now.
Right, we'll bring that up as they come.
Yeah, but there will be more coming, and most of those are cases where other law firms have reached out and they want to bring us in for the skills that we bring to the table, and specifically the skills Erik brings to the table. So we're always available to work with other firms. If you're a lawyer watching this and would like to talk with us, please reach out and we'll see how we can help. Otherwise, things are still kind of in disarray with what's been going on with the Supreme Court, and we're kind of regrouping. That's some of the things that have been going on is why we've been a little short on our video schedules, but we're back in business with that, and we appreciate your patience. And I look forward to talking to you again. Erik, do you have anything else you want to add?
No, thank you much.
Well, thank you very much.